State of Michigan Department of State Police. First Lieutenant Dwayne Zook and Stephanie Horton. And I believe that both Mr. Zook and Ms. Horton have been sued in their individual capacity. There seemed to be some disagreement about that, but Mr. Mungo, I think you're absolutely right. Your pleading identifies those two in their individual capacities, correct?
That is correct, Your Honor.
All right, so let me just talk to Ms. McCormick for a moment before we get started. As I understand it, this was filed in the Wayne County Circuit Court in the first place, and then it wound up being moved to the Court of Claims.
Yes.
I take it that you are only representing the State of Michigan Department of State Police. Is that right?
For this motion, we also represent defendant Zook.
But I presume with defendant Zook, that would have to go back to Wayne County because he's sued in his individual capacity.
Well, our position is that the lost wage claim component needs to be decided here, Your Honor.
Okay. Well, let me ask you this. With regard to Ms. Horton, does that have to go back to Wayne County?
I don't represent
Yes.
Ms. Horton, but
Yes. Yes,
Okay.
both, as you indicated, Judge, both should, yeah, both individuals.
Right, right. My problem with these cases, and this is about the fourth one I've had, the whole case gets pulled from a circuit court to the Court of Claims, and then I wind up having to separate the Court of Claims part of it from the circuit court part of it. And so, Mr. Mungo, your position is, and I'm not making a final decision on this today, that the only defendant that I can deal with here is the Department of State Police.
That is correct, Your Honor. That is
Okay.
correct. And I'm not going to say anything further until you tell me I can. So I do have more to say on that.
Oh, sure, sure. Okay. Well, I'll tell you what then. The way that I typically do this, and I was a circuit judge for a long time, is I try to give you an indication of what I think, and then I let you go ahead and make all the arguments you want in reaction to that. So let me just start out describing what I know about this case and then what I think about this case. Case was filed on February 9th, 2024 in the Wayne County Circuit Court. It alleges 3 claims under the Elliott Larson Civil Rights Act. One claim is for race and color discrimination. One claim is for gender discrimination, and one claim is for retaliation. The 3 claims seem to arise out of a series of events. I don't think there's any question that Mr. Palmer worked for the Department of State Police and was promoted in that capacity. And at some point, he sought an additional promotion and then another additional promotion, and he was denied both of those promotions. And the complaint alleges that in each case, the person who was put into the position that Mr. Palmer wanted was a white woman. And so that's the basis for claims of both race discrimination and sex discrimination. Now, what brings us here today is that I believe it's only on behalf of defendant Michigan State Police Department. That certainly is what the motion for summary disposition says. I've been asked to grant summary disposition for the State of Michigan Department of State Police and against Mr. Palmer only on all 3 claims under MCR 2.116C7 because the notice of intent to sue was filed outside what the defendant believes was the appropriate 6-month period with regard to each one of the 3 incidents. Now, as far as I can tell, the outcome of this motion turns largely, if not entirely, upon whether there's a 1-year period to file the notice or only a 6-month period to file the notice. I believe the defendant takes the position that this is in the nature of a personal injury action, and so that triggers the 6-month period. And I believe that the plaintiff argues under both the Revised Judicature Act and more general principles of defining what is a personal injury, that this should not fall within the 6-month period of limitation. I think that all we're talking about is the timing of the notice of intent to sue. We're not talking about the complaint itself. We're not talking about verification. In other words, the Court of Claims Act prescribes both a verification requirement and a notice requirement, and the notice has a time limit on it. You have to file the claim or the notice within either 6 months or a year. And so obviously, to the extent that I have to make a decision here, it's largely controlled by Christie and Elia companies, but those two cases don't really tell me anything about whether a claim under the Elliott Larson Civil Rights Act is or is not a personal injury action. That's what I know. Why don't I let you go ahead and get started, Ms. McCormick, and then Mr. Mungo, you can respond. And the way I handle motions is I let each side argue twice. So Ms. McCormick, you'll start us off. Mr. Mungo, you will be the anchor leg in this relay, and we'll get to the end of it, and I'll see if I can decide it from the bench. So why don't you go ahead first, Ms. McCormick?
Thank you, Your Honor. We are asking for summary disposition based on, as you've said, the notice failure to comply with the notice requirement. In this case, the notice requirement is 6 months. And so why is that? You're absolutely correct. There is not one exact case on point that talks about ELCRA being personal injury. I would love to be able to cite that to you. However, there are a number of cases that we've cited within our brief and within our reply brief, where in a statute of limitations action, the Court of Appeals has held that Michigan's general 3-year personal injury statute of limitations governs under ELCRA. And we attached the Borman decision, which is Exhibit A, to our motion for summary disposition. And while that is unpublished, I think that it provides great guidance to this court. In Borman, that was a sexual harassment and sexual assault claim against a former University of Michigan lecturer. And the Court of Appeals in that decision determined that the 6 plaintiffs in that case filed their written notices of intent well beyond the 6 months after the last alleged incident of sexual harassment or sexual assault, and therefore it failed to comply with the notice requirement of 600.6431. I think also if the court looks at the common definition of personal injury, that involves a harm to a person's body or the invasion of personal rights. And here, if you look at what Mr. Palmer alleges, he's alleging an invasion of a personal right, his ability to make money by being promoted. And that's based on allegedly the MSP intentionally discriminating against him. Furthermore, if you look at the cases that we cited within our brief, one case being Stringer versus Board of Trustees, the deprivation of civil rights, so employment opportunities because of race, those are considered injuries to persons in both in statute of limitation actions, as well as having a right to one's good name and advancement in a chosen profession. Those are rights entitled to a person just by reason of being a person. And so if you use all of this case law, if you look at what the Court of Appeals has looked at in terms of what personal injury is, then you come to the conclusion that this is a 6-month notice requirement and not the 12-month. In terms of,
Can I stop you and ask you a question, Ms. McCormick? I suspect you're going to tell me it's just loose language, but in Christie versus Wayne State University, I know you're familiar with it. On page 46, it says, plaintiff filed a civil complaint against defendant in the Wayne Circuit Court alleging that defendant violated the ELCRA, Elliott Larson, and the PWD CRA. Defendant responded by moving for summary disposition pursuant to MCR 2.116C7, asserting that plaintiff was required to file either a verified complaint with the Court of Claims or a notice of intent to file suit with the Court of Claims within 1 year of the accrual of her claims pursuant to MCL 600.6431 paren 1 close paren of the Court of Claims Act. That's an Elliott Larson case, and yet the defendant in that case said it was a 1 year period.
And are you asking me if I believe that that's on point to this issue?
Well, I mean, that's the Supreme Court describing how that case unfolded. Are you saying that that's just a poor argument made by the defendant, Wayne State University, in that case, and they should have said 6 months?
I think what Christie didn't have to argue was they didn't file a notice in that case. They didn't file a notice at all. What that wasn't the issue in Christie, was that they filed an untimely notice. That's what we have here is
I get it. So what you're saying is the reference to 1 year for an Elliott Larson Civil Rights Act is just an explanation of the procedural history of the case. It has no bearing on whether it's actually 6 months or a year. Is that your argument?
Yes.
Right, because I couldn't help but notice when I went back through Christie that they referred to 1 year on an Elliott Larson claim. I'm not saying that that's in any way the holding of the court. It's under basic facts and procedural history, but I just thought you should respond to that.
And what I would, and yes, that's exactly what our position is that Christie wasn't dealing with an untimely notice and making a determination whether it's 6 months or 1 year. They're simply citing the beginning of that particular statute, which holds for 1 year, but that wasn't what Christie was decided on. And I do want to point out bring a recent case to the court's attention. This just was decided by the Court of Appeals on June 20th of 2024. So that is why you wouldn't find it in any of our briefing, but it's Genuine Solutions Counseling Center, PLLC versus Governor, State of Michigan. And it is unpublished. I'll give you the Westlaw site is 2024 WL 3083367, docket number 364180. And in that case, the plaintiff there attempted to make the same argument as Mr. Mungo has made on behalf of Mr. Palmer in the amended response that he filed, which he didn't have leave to file, but
I'm sorry, counsel, what was that case again, please? I apologize for interrupting.
Sure. Genuine Solutions Counseling Center, PLLC versus Governor, State of Michigan, docket number 364180, decided on June 20th, 2024.
Okay, and what does that say?
And this goes to the revised Judicature Act question about, well, there's a personal injury definition in the RJA, and Genuine Solutions that holds that that RJA personal injury definition is only contained in Chapter 63. It does not apply to Chapter 64, which is the chapter that we have here for notice requirements.
Chapter 64 being the Court of Claims Act?
Correct. And so that was somewhat plaintiff's position as to, you know, why this isn't seen as a personal injury, not 6 months. And that definition only applies to the previous chapter, Chapter 63. And that case supports that. And if you look at the act, it specifically says this is you know, limited to this particular section. So you know, our position is that
right. I see what you're saying, because even if you read their brief on page 3 of their amended brief, they're quoting from a case called Angelucci versus Dart Props Inc. The phrase personal injury is not defined in Chapter 16 of the revised Judicature Act, the chapter containing MCL 600.1641. However, personal injury is defined in chapter 63 as used in this chapter, personal injury means. And so
Yeah.
what you're saying is there's limiting language on the definition itself in chapter 63 that says, quote, as used in this chapter. I understand that, but it looks like from this Angelucci versus Dark Props Inc. case, they at least borrowed from chapter 63 to apply it in chapter 16.
That's right.
Well, and in the Genuine Solutions Counseling case, they look at, since they take out personal injury definition from 63 and say, well, that's not, they hold that's not applicable here. They go to really the common dictionary definition of personal and personal injury, and basically find that it's defined as harm or damage done or sustained, especially bodily harm, and any violation of the rights, property, etc. of another for which damages may be sought. And they go into some analysis of personal injury, and they basically decide that based upon a dictionary definition, a personal injury is harm that is caused to an individual's person's body or an invasion of personal rights. And so here we have Antonio Palmer. First of all, he alleges in his complaint, in numerous places in his complaint, that he suffered personal injuries, mental injuries. So he alleges, number one, in his complaint that he suffered from personal injury, but also we have a violation of an alleged violation of a right to he alleges professional advancement, he alleges reputation. And this is all based on allegedly the MSP intentionally discriminating against him.
All right, slow up just a second. Help me understand exactly what you're trying to convince me. I think what you're trying to tell me now is even if we take Mr. Mungo's approach and borrow the definition of personal injury from chapter 63 of the Revised Judicature Act in 600.6301 (B) close paren, it still qualifies as personal injury, because even under that definition, personal injury means bodily harm or emotional harm resulting from bodily harm. Yep. And are you saying that that's what a civil rights claim is?
I would not borrow from the personal injury definition in chapter 63. I think what I would submit to the court is that the Court of Appeals recently in this Genuine Solutions case has looked to the Random House Webster's College Dictionary to look at what the terms personal and injury mean, and have applied those common dictionary terms, because the legislature was silent in the Court of Claims Act. They could have carried over the personal injury definition from chapter 63 and put it into 64, and they didn't. And in fact, they used limiting language in 63 to make it known that it wasn't applicable in other provisions. So what I would suggest to the court is, in looking at not only what the allegations of Mr. Palmer's complaint allege, but looking at the definition of what personal injury, those words mean, and how the Court of Appeals recently, as of late June of 2024, have interpreted those words to mean that we're looking at harm that's caused to an invasion of personal rights. That's exactly what Mr. Palmer's, complaint alleges.
Right, and I understand that that's a case of recent vintage, but your brief refers to a couple of older ones, which I think make the same basic point. Stringer says the deprivation of civil rights, e.g. employment opportunities because of race, were considered as injuries to person. And then Barnes versus Double Seal Glass says a civil suit for damages based upon an alleged violation of the plaintiff's right to employment without sex discrimination is in the nature of a tort action and as such concerns a personal injury to the plaintiff.
Correct.
I mean, what you're citing to me is an unpublished opinion. Those are published opinions, right? I mean,
Yes.
I know they're before the cutoff, but I'm not sitting as the Court of Appeals now. I'm sitting as a trial court judge, and those decisions are binding on me as a trial court judge.
Yes.
The Court of
Absolutely.
Appeals panels are
Absolutely
free to reject decisions from before 1989, but as trial court judges, we're not allowed to do that. We're stuck with what the Court of Appeals said, even if it's of vintage before November 1, 1989, correct?
Correct.
Okay. Yeah, because we got all hung up on that in one case where somebody was trying to argue that the trial judges aren't required to follow anything issued before November 1, 1989. I thought, wait a minute, that's not right. The Court of Appeals panels aren't bound by it, but the trial courts are. All right, so to sum up your argument as best as I can, for lots of reasons, you don't want me to borrow this definition of personal injury from MCL 600.6301 (B). And whether I look to a dictionary as this recent unpublished case called, I don't know what, I didn't write the name down, I wrote the site down. Whether I go to that or whether I go to the binding published opinions from the 1980s, I wind up at the same place, that a claim under the Elliott Larson Civil Rights Act is necessarily a claim involving personal injury, and therefore it falls into that category under MCL 600.6431 where you must file the claim or notice with the clerk of the court within 6 months. Yes?
Yes.
Okay. Anything else you want to tell me?
No, other than that Mr. Palmer cannot cure his defective notice. So no, I
Right,
mean,
yeah, it's way past time. And I hate the fact that a lot of people got caught up in the published decisions from the Court of Appeals that said both what happened in Christie and what happened in Elia Companies was okay. But I ought not worry about that this much, I guess, because those cases were issued in the summer of 2023. And here we didn't get the notice until sometime later in 2024, right?
the notice of intent was September of 2023.
Okay, September of 2023, right, after Christie and I knew it was post Christie and Elia. Sorry, I'm off a little bit.
Yep.
Okay, I got it.
Yep.
Anything else you want to tell me?
No, I just under the 6 months, all three of his claims, they're past the accrual. I think the last accrual date would have been June 2023. And the
Oh,
notice came in-
I do have one more question I want to ask you. As far as what stays and what goes back, I think you and Mr. Mungo and I have all agreed that all claims against Ms. Horton have to be resolved in the Wayne County Circuit Court. Is that right?
I don't know that I
That's
agree
correct.
with that or not.
If I'm wrong, tell me why I'm wrong, because I can't imagine how in the world an Elliott Larson Civil Rights Act claim against an individual sued in her individual capacity has to be in the Court of Claims. I don't understand that at all.
I would much rather, I think, argue this in front of with Zook than I feel uncomfortable arguing with Horton because I don't represent Horton.
Okay, well, all right. Well, what about Zook then? Because I don't understand how Zook stays in the Court of Claims either.
Mr. Palmer is alleging back pay and front pay. And I believe the notice to transfer, and I think that would be filed in your file as well, Judge. There's case law that the equitable relief that he seeks, specifically the front pay, that has to be determined, obviously, because it's equitable relief.
Wait, are you saying that front pay is equitable relief? How can that be? Equitable relief is injunctive relief or declaratory judgment or something like that.
Yeah.
Equitable relief is the front pay, and that's why.
Boy, you and I are gonna have to agree to disagree on that, because I think you're completely wrong about that.
I can look for, I don't have that right.
Yeah,
in
you don't
front
have,
of me.
look, we don't have to solve that today.
Yeah, I mean, I would be happy to brief that, Your Honor, if that's, if
Okay,
that's.
yeah, because I mean, if you can find me any case from anywhere in the country that says front pay is equitable relief, I'll give you a medal. I don't think you'll find a case anywhere in the country that says that. Okay, well, let Mr. Mungo argue for a while. Mr. Mungo, let's not get too hung up right now on Mr. Zook or Ms. Horton. I mean, I am almost 100% sure that those go back to Wayne County, and I take it you agree with me.
Absolutely. Absolutely. Yes. Yes. So the issue that's before the court today is very narrow, and that is the statute of limitations for complying with the Court of Claims Notice Act, notice of intent, or the time frame in which a notice of intent is to be filed. And the argument the counsel just made using the unpublished case that she just brought to the court's attention, I think it was June of 24. Number one, it is unpublished, and then number two, the case that I cite, the Angelucci, and I commend Judge, both you and counsel, for pronouncing that name much more accurately than that case. And Judge, you were spot on all fours when you said that you recognize that the court in Angelucci applied the definition of personal injury contained in Section 63 of the Revised Judicature Act to another statute which dealt with statute of limitations.
Right.
And that's the way it ought to be. It's the way it ought to be. And I think a statutory definition that was followed by another court in a published case that renders the definition of a personal injury should trump that of Webster's dictionary or even Black's dictionary for that matter, as well as an unpublished case. And it just makes sense that from reading Section 63 that a personal injury means bodily harm, sickness, disease, death, or emotional harm, which is what we're alleging, right. Emotional harm, but it has to come from that. It has to result from a bodily injury. And there are no claims of bodily injury, either in the background facts of Mr. Palmer's complaint, nor in any of the briefs that we've submitted to the court, or anywhere are there claims of a bodily harm being done to Mr. Palmer.
But Mr. Mungo, you have to agree with me that as a general rule, claims of civil rights violations are treated as personal injury claims, both as a matter of Michigan law and as a matter of federal law. I mean, there's so many cases that hold that I understand what you're saying. If a statute defines a term differently than it's been defined by all the courts, the statutory definition can trump the court's decisions. So I'm not disagreeing with you on that proposition. But in order for you to succeed, I think you have to rely on that statute, and I have to find that it's borrowed for purposes of Chapter 64 of the Revised Judicature Act too. Because if we look to anything else, and I'm not big on looking at dictionary definitions when they're published decisions from our court, but if I look to anything else, I'm going to find that an Elliott Larson claim is in fact a personal injury claim. Am I not?
Well, I think, first of all, what you cited is factually accurate and tracks the history of the court's treatment philosophically of a Civil Rights Act. And I think you may even find in support of what you're saying, Judge, the language being used by our courts that it sounds in tort even.
Yep.
However, when we come to a fork in the road where we have a more concrete direction and a pathway that we're legally bound to follow in making these bottom line assessments about whether the statute in the Court of Claims Act allowing us or requiring 6 months for personal injury and a revised Judicature Act that's been followed in another published case in terms of following its definition of personal injury.
Right.
I don't think.
If I can give you a ridiculous hypothetical to show you that I understand your point, and I think you're right about what can be done in a definition. If the legislature defines personal injury for purposes of the Court of Claims Act to mean losing your right leg, then even if you just lose your left leg, it's not a personal injury because the legislature said it's only a personal injury if you lose your right leg. Now, that may be crazy, but if the legislature wants to define a commonly understood term to mean something much more narrow than that, it has the power to do so. I presume you agree with me on that, right?
I do.
And so that's what you think has happened here. They've gone out of their way to narrowly define personal injury, and that should apply.
Yeah, I think the court has. The court went to Section 63 to borrow that definition, as you accurately stated earlier, to borrow that definition to resolve a legal question. And if it applies there in a published case, why shouldn't it apply here?
Right.
I mean, and I'm looking at, and in the course of these cases, Judge, that's been involving, and you know, Christie has thrown us all in a tizzy.
I know, and I feel bad for everybody trying to litigate these cases. I mean, Christie and Elia came like a bolt from the blue. I was frankly stunned when it came down, and especially that they were unanimous.
Yeah, exactly, Judge. And I think that what we have experienced is a real kind of a shock, legal, especially at the plaintiff's bar.
Sure, of course.
with regard to this case. But one thing I believe, and in studying some of the cases in terms of dealing with this newfound issue, or I should say, battleground that Christie has opened up here, right. Our cases that define, that says that judges should not legislate from the bench.
Absolutely, couldn't agree more.
And that's what would be happening here if we followed and granted sister counsel's argument and request for relief here.
Well, I've gone over your complaint very carefully, Mr. Mungo. I presume you concede that if the 6-month time limit applies, that you're outside it with your notice, because it looks to me from everything I've read that the pattern of conduct on which you base your Elliott Larson claims was from approximately June 2022 to December of 2022. Am I right about that?
Whoa, let me, I am so sorry, Judge. I do not have that in front of me. It's
right. I mean,
notice.
Right. For example, paragraph 19 of your complaint says, beginning on or about June 2022 to November 2022, plaintiff complained to DZ, SH, and his immediate and non-immediate supervisors about being passed over for the promotion. So that means he was passed over sometime before that, and November 2022 would be the latest possible date, because that's when apparently they forced him to start going to this new workstation that was 80 miles from his house. That happened in November 2022, according to paragraph 20. Does that sound about right?
That sounds about right. I do not have that in front of me, Judge, but I have no reason to think or believe that you're not reading that accurately.
Okay, that's fine. And then the last thing you have in paragraph 21, it says, on or about December 2022, plaintiff applied for a posted position for sergeant, for which he was qualified at the defendant's MSP's Lansing post, was not selected for that position. So it looks to me like if it's a year, you're inside the time limit, and if it's 6 months, you're outside the time limit.
That is correct. That is
Okay.
certainly.
Okay, that's fine. So really, this all comes down to one very simple question. Is it a 6-month period or is it a 12-month period?
Your Honor, but please forgive me. Please forgive me. But there's just one thing that I want to point out.
Of course.
The court would suffer me to do so, is that as the court makes its ruling, I want to point out that the notice requirements does not apply to individuals, only to the state.
Oh, okay. Okay, I got it. I'm sorry, and you're right about that. I'm sorry. Mr. Mungo, I'm so convinced that you're right that I have no business dealing with the individuals that I haven't even thought about them. And I'm sorry about that. I know that they're still trying to keep, I guess, Mr. Zook here for a little while longer, but I can't see any way that you're wrong about that.
Well, Your Honor, one other just tiny point here is that counsel agreed with me that both these individuals were named in their individual capacity.
Yes, no question about it.
Okay.
Right. I mean, if there's any doubt about that, because their motion refers to Mr. Zook in his official capacity, I went back and checked your pleading. Yeah, there's no question, start to finish. You have sued him in his individual capacity.
Yes. Thank you, Your Honor. I
Yep.
apologize for interrupting.
Oh, no, it's fine. All right, Ms. McCormick, you want to say anything else? And then Mr. Mungo, I'll give you the last word and then I'll see if I can work my way through this.
Well, the last word would be from my perspective, as far as the personal injury definition that we keep going back to. All you have to do is look at the definition, the 600.6301 sub B, and it says, as used in this chapter. I can't, I mean, there isn't any more limiting, I think, language that the legislature could come up with than as used in this chapter. So I don't think that based on the Stringer case that we cite, as well as the other cases in our brief, I don't think that there's any real grounds, certainly in light of what we've talked about in this Genuine Solutions, which I understand is an unpublished case, Judge, but I don't think that there's any reason to apply the personal injury definition from the RJA from a different chapter, and I don't think that that's applicable here.
Can I ask you a question? How much weight do you want me to put on Browerman? Because it looks to me as I go through Browerman, and it's the second time I'm reading it, but it is an Elliott Larson case, I think. I wasn't able to absolutely make sure of that. And it was against an entity defendant, and they did apply the 6-month limitation period.
Yeah, I mean, our position is Browerman is obviously helpful, but there are more cases that are more on point. And I think those are what we cited in our brief. The line of cases that deal with civil rights actions in federal court, as well as I mentioned, the Stringer case we've talked about a number of times, where that was based on a deprivation of civil rights and employment opportunities. And that's what Mr. Palmer's alleging here against the MSP. So we would ask, based on, obviously established case law, knowing that there isn't a case on point with ELCRA, I understand analyzing the 6 months, but I think there's enough. Our position is there's certainly enough for this court to use as that's precedent. Not all the unpublished opinions. That's not all we have. Not just a dictionary definition. But if you use all that together, and you look at what Mr. Palmer is alleging here, race discrimination, sex discrimination. I mean, this is a deprivation of his personal rights. It's because he's a person. It's rights that he's alleging he's entitled to as a person. It's a personal injury, and it's the 6 month. And what I would mention when there was a discussion about his claims and the accrual of his claims, you know, our position obviously is the 6 month, but even if you look at the 1 year, he does allege a discrimination claim arising from facts in June of 2022. He didn't file his notice of intent until September. So I don't know if those are covered as well. I mean, I see June, November, and December is the timeline, but
Right.
I
I read it the same way you do. That
okay.
The first Passover was in June 2022.
Correct.
The second Passover was in
I think
December 2022, and the retaliation was in November 2022.
Right. That's how we at least have seen the allegation. So
Yep. Yeah, that's how I line up the dates.
and so respectfully, we would request a summary disposition on behalf of Michigan State Police based on a failure to comply with the notice requirements here, Judge. Thank you.
Okay, thank you very much. Mr. Mungo, you get the last word, and you may say whatever you like, sir. I'm happy to listen.
Well, Yana, I don't think there's very much more to say. You know, not that I'm happy about that, but I don't think that there's very much more to say.
Okay.
There just isn't. I mean, this is clean and clear to me that we have unpublished cases, Webster and Black's Dictionary versus a provision in the Revised Judicature Act and a published case going in plaintiff's direction here. I don't think there's much more to say. I think anything else is a strain and a stretch that is not found to be non-insulting by our judicial system.
All right, thank you very much. Well, let me see if I can decide this one right now. I've gone 3 for 3 so far today, ruling from the bench. You get decisions a lot faster if I do it that way, and I'll never understand this case better than I do right now. So let me start at the beginning and explain what I'm doing. What we have here is a motion for summary disposition under MCR 2.116C7. And if you'll excuse me for just one moment, I have to go grab a book that I put on the shelf, and I now realize I need again because I used it earlier. I'll be right back, and I apologize for the slight delay. My fault. All right. Now, I apologize for the slight delay. Now I have the book in front of me I need, and I can proceed. As I say, the motion here is a motion for summary disposition under MCR 2.116C7. C7 provides that a motion for summary disposition may be raised on the ground that a claim is barred, among other things, by the statute of limitations, or in this case, the limitation period set forth in the Court of Claims Act. When reviewing a motion under MCR 2.116C7, this court must accept all well-pleaded factual allegations as true and construe them in favor of the plaintiff unless other evidence contradicts them. That's Dextrom versus Wexford County, 287 Mishap 406 at 428, a 2010 case. Continuing from Dextrom, quote, if any affidavits, depositions, admissions, or other documentary evidence are submitted The court must consider them to determine whether there is a genuine issue of material fact. If no facts are in dispute, and if reasonable minds could not differ regarding the legal effect of those facts, the question whether the claim is barred is an issue of law for the court. However, if a question of fact exists to the extent that factual development could provide a basis for recovery, dismissal is inappropriate. All of that is from Dextrum 287 Mishap at 429. I'm satisfied after reviewing the complaint and talking with counsel this afternoon that there is no factual dispute that stands in the way of making a decision. What do I mean by that? If you look at the allegations in the complaint, which is really the starting point for analysis under MCR 2.116C7, you see three different violations alleged by the plaintiff. The first is that on or about June 2022, the recruiting sergeant position was posted. Plaintiff applied for that position, and a much less qualified white female who worked under plaintiff's supervision while he was acting sergeant of recruiting was selected to fill said position, close quote. That's paragraph 16 of the complaint. That's violation number 1 alleged under the Elliott-Larsen Civil Rights Act. Then going to paragraph 20 of the complaint, it says that on or about November 2022, plaintiff, as a result of his complaining, reporting, and protesting being unlawfully discriminatorily denied promotions and career-enhancing assignments, was ordered to report to the Metro South Post as his new work location 80 miles away from his home. He was ordered to drive daily from Lansing to Detroit and back to the Lansing area where his home is located, which was 160 miles a day. The defendants ordered plaintiff to do that each and every workday out of retaliation against the plaintiff, to punish the plaintiff, close paren, for engaging in protected activity. That's the second violation of the Elliott-Larsen Civil Rights Act. And finally, in paragraph 21 of the complaint, it alleges that on or about December 2022, plaintiff applied for a posted position for sergeant, and for which he was qualified at the defendant MSP's Lansing post, approximately 4.5 miles from plaintiff's home. Plaintiff was not selected for that position out of retaliation against plaintiff for engaging in protected activity and or for reasons of plaintiff's race and or gender. That's the third violation alleged. So we have violations in June, November, and December of 2022 that form the basis for the 3 counts of race, color, gender discrimination, and retaliation. We also know, because it's attached to the complaint, that the notice of intent in this case was filed on September 1 or 2 of 2023. The date on the notice of intent is September 1, 2023. And I think there may be some reason to think it was filed a day later. But in any event, as I discussed at length with Mr. Mungo, it appears that if the 6-month period applies, that all of the claims are barred under the Court of Claims Act. But if the 1-year period applies, at least 2 of the 3 claims are plainly viable. So the question then turns to how to apply the Court of Claims Act, and particularly MCL 600.6431. Subsection 1 of MCL 600.6431 states, except as otherwise provided in the section, a claim may not be maintained against this state unless the claimant, within 1 year after the claim is accrued, files in the office of the clerk of the Court of Claims either a written claim or a written notice of intention to file a claim against this state or any of its departments, commissions, boards, institutions, arms, or agencies. I'm going to stop And note parenthetically that Mr. Mungo is exactly right that that bar provision cannot apply to the individual defendants in this case. To the extent it can be invoked, it can only be invoked by the entity defendant, the Department of the State Police. And so what I say today from here on out has nothing to do with Mr. Zook or Ms. Horton, the individual defendants sued in their individual capacities. However, for claims involving property damage or personal injury, the claimant must, quote, file the claim or notice under subsection 1 with the clerk of the Court of Claims within 6 months after the event that gives rise to the claim. That statutory site is MCL 600.6431 So in other words, there's a distinction that needs to be drawn in the analysis here. Most claims that are filed against state entities have a 1-year period for filing of either the claim or the intent to file the claim. But if the claim involves property damage or personal injury, then the period is shortened to 6 months. It certainly appears that if the 6-month period applies, all the claims are barred against the Department of State Police. If the 6-month period does not apply and it's a 1-year period, then at least 2 of the 3 claims plainly survive. So the question is whether this case involves personal injury. Now, under Michigan law, there's a well understood concept that civil rights claims, like a claim under the Elliott Larson Civil Rights Act, would be treated as personal injury claims. The Court of Appeals said so in Stringer versus Board of Trustees, 62 Mich. App 696 at 701, a 1975 case, where the Court of Appeals said, quote, the deprivation of civil rights, e.g. employment opportunities because of race, were considered as injuries to person, close quote. Similarly, in Barnes versus Double Seal Glass Company, 129 Mich. App 66 at 73, a 1983 case, the Court of Appeals said, quote, a civil suit for damages based upon an alleged violation of the plaintiff's right to employment without sex discrimination is in the nature of a tort action, and as such concerns a personal injury to the plaintiff. Now, I am bound, obviously, to follow the decisions of the Court of Appeals that are published, regardless of the year of publication when I sit as a trial court judge. And so I begin my analysis with the obligation to follow that definition of a civil rights action being treated as a personal injury claim, unless I have a reason to disregard those published opinions of the Court of Appeals. Mr. Mungo, on behalf of his client, has presented a statutory argument that he believes takes this case out of the published definitions, stating that civil rights claims are personal injury claims. Specifically, he relies on MCL 600.6301 small b, close paren, which is in Chapter 63 of the Revised Judicature Act. According to that provision, quote, as used in this chapter, ... for the ellipses, personal injury means bodily harm, sickness, disease, death, or emotional harm resulting from bodily harm. Now, as Mr. Mungo correctly points out, in the case of Angelucci versus Dart Props, Inc., which doesn't have a cite in his brief, but I certainly believe the case exists. There it is, 301 Mich. App 209, a 2013 case, excuse me. There is a cite in the brief, I apologize. There, the phrase personal injury was not defined in Chapter 16 of the Revised Judicature Act, but nonetheless, the definition of personal injury in chapter 63 was borrowed to apply to 600.1641 of the Michigan compiled laws. In this case, I've done my best to try to figure out what guidance I have that could convince me whether to borrow from chapter 63 of the Revised Judicature Act to apply it to chapter 64 of the Revised Judicature Act. And the best guidepost I can find is the unpublished opinion of the Court of Appeals in Browerman versus the University of Michigan, an unpublished case, docket number 363879, decided December 21, 2023. In that case, the Court of Appeals was presented with a challenge to the timeliness of the notice of intent to file suit, and the suit to be brought was a violation of the Elliott-Larsen Civil Rights Act. As a matter of fact, in the opinion, the court talks about the Elliott-Larsen Civil Rights Act as the basis for the claim in discussing the transfer of the case in part to the Court of Claims and leaving some of it back in the circuit court. There, the Court of Appeals, in the course of its analysis in section 2B of the opinion, clearly treats the Elliott-Larsen Civil Rights Act claim as a personal injury claim that's barred under the 6-year bar period prescribed by MCL 600.6431 And even though it's an unpublished opinion, I have no better guidance than that to determine how to treat an Elliott-Larsen civil rights claim asserted in an action before this court or a circuit court under the Court of Claims Act. I want to make two observations before I render my final ruling. The first is that Mr. Mungo has certainly described a plausible theory in borrowing the definition of personal injury from MCL 600.1641. Although I think that even if you go with that definition of personal injury as, quote, bodily harm, sickness, disease, death, or emotional harm resulting from bodily harm, there's a strong argument to be made that even under that definition, a civil rights claim would constitute bodily harm. The other observation I want to make is that this is one of those cases that arose during the period of Christie and Elia companies not yet being in force. As I said, the specific alleged violations here occurred in June, November, and December of 2022. And at that point, nobody thought, because there was binding Court of Appeals precedent to the contrary, that you even had to file a notice of intent in a timely fashion under the Court of Claims Act if you initiated your case in the circuit court. Now, the complaint in this case was filed in 2024. The notice was filed in September of 2023. Christie and Elia companies came out in May of 2023. And so they were both in effect when the notice was sent in this case. And I suppose if there had been an extraordinary amount of quick work when Christie and Elia dropped on May 2nd of 2023, 2 of the 3 claims could have been saved under the 6-month period. But it's hard to fault anybody for knowing that this was coming. And I think Mr. Mungo is correct that it's at best a bolt from the blue and at worst fundamentally unfair that people who are caught in this period will have their claims rejected for failure to comply with the timing of notice within the 6-month period. Unfortunately, Christie and Elia are very clear that there's one and only one possible remedy under these circumstances, in spite of however sympathetic I might feel. And that remedy, as Christie and Elia both dictated, was dismissal. Now, for that reason, and for that reason only, I'm going to grant the motion for summary disposition in favor of the State of Michigan Department of State Police and against Antonio Palmer under MCR 2.116 (C) close paren 7 close paren. In doing so, I want to make clear that I'm rendering no decision whatsoever against either Mr. Zook or Ms. Horton, whose claims I believe should be sent forthwith back to the Wayne County Circuit Court for resolution. I'll probably issue an order to show cause why they shouldn't be sent back immediately. And the other point I'll make is that if there's to be an appeal in this case, I would indicate for the record that this is one of the most difficult cases to justify in applying Christie and Elia, because there's no way anybody could have seen that coming. So with that, I don't know how to describe it, with that expression of sympathy, I guess, I'll issue an order granting summary disposition only with respect to the entity defendant here, and we'll see what happens next. I take it, Ms. McCormick, that you may want to fight over at least part of the claim against Mr. Zook going back to the Wayne County Circuit Court?
Yes.
All right, so what I'll do then is I'll issue an order to show cause, indicating that I'll give you 3 weeks to show cause why I shouldn't just send the whole case back to the Wayne County Circuit Court, because I don't want to delay justice any longer in this case. There are still two perfectly viable defendants, and Mr. Mungo has every right to proceed against them in the Wayne County Circuit Court, in my estimation. Okay?
Thank you, Your Honor.
All right, thank you all very much. I will get the orders out tomorrow, and we'll proceed if you respond to the show cause order. Okay?
Thank you, Your Honor.
Thank you,
Thank
everyone.
you.
All right.
And you can take us off the record.
And we're off the record.
Yeah, and now we can shut down the session because we've been keeping it up all afternoon. All right, thank you all for your patience.
Thank you, Your Honor.
Thank you.